Well, welcome to another webinar of the Catholic Academy of Communication Professionals. This is Brian Finnerty, First Vice President for the Catholic Academy, U.S. Communications Director for Opus Dei. We're here today with Bridget Colbert, Assistant General Counsel at Santa Clara University. She's agreed to come back and answer questions that we have about intellectual property. And so the webinar that she gave before had been very successful, and we have had a lot of questions at the end of that. So our format will be, she will give a quick rundown of some of the basic points that we need to know as Catholic communicators about intellectual property. Some of the, a fuller version of these notes that she's going to go through is on the Catholic Academy website at catholicacademy.org. And so we'll hear a brief overview from her. But then the major part of what we're doing today is just whatever questions people will want to ask, she's there to answer our questions. So Bridget, thank you so much for being with us.
Thanks, Brian. I'm really happy to be back. Our last session I thought was a lot of fun, and I'm hoping that this one will also be a good source of information for your participants. So I'm going to share my screen. And I have just a few slides. Like Brian said, it's sort of a condensed version from last time, and I know that the slides from the last webinar are already up on the website. So this is just mostly answering questions. I'll have about 10 minutes we'll go over to frame the conversation around intellectual property, and then we can get going on our questions. So there we go. All right, so we're going to be talking today mostly about trademarks and copyrights. A copyright is indicated by a C with a circle. A copyright just means that if somebody creates something, that they own it. And an example of what a copyright notification is this one that I have here on the slide. I took that directly off of the email that invited all of you to this webinar. Something simple like that lets people know that the Catholic Academy of Communications Professionals owns what's written in that email, and you can't use it without their permission. A registered trademark is an R with a circle, and an unregistered trademark is the TM. If you have a trademark, you don't necessarily need to write anything on it, especially similarly with copyright, but it's a good way to let people know that your trademark is owned and that they can't use it, just as your written work is owned and they can't use it. Copyrights and trademarks automatically attach to a work. You don't need to register them with the federal government for your work to be protected. So if you write a novel, you don't have to get a copyright from the federal government for it to be copyrighted and protected, and third parties can't use your work without your permission. So copyright basics. Copyrights are protected by federal law. Copyrights cover fixed works only. So it's something that's actually written or that you can physically hold, like a book, a manuscript, music, written music, a movie that's recorded, sound recordings, architectural drawings, things like that. So if you create something that's written that you can hold, or that's recorded in some way that you can touch, you own that work. As I said before, copyrights automatically attach. You don't have to register them with the federal government for them to be protected. However, if you notice that somebody is using your copyrighted work without your permission, and you want to use the legal system to protect your work, it's probably best then to register your copyright. It can be done at any time. It's not something that you have to do right away, or just simply writing a letter and telling them that you own it is another good way to just protect your copyright. So copyrights, the duration of a copyright, in general, anything created after January 1st, 1978, the copyright protects the work for the life of the author plus 70 years. If the author is a company, because it's a work for hire, or anonymous, it's 95 years from the first publication, or 120 years from when it was created, whichever occurs first. For works that were published, that were created but not published before 1978, it's a little bit different because the law changed January 1st, 1978, but really, if it was published before 2002, the copyright will expire in 2047. It's not likely you're going to ever need to know this, but just in case it comes up, you have this slide that you can refer to. Trademarks are protection of names, logos, slogans, seals, other insignia that identify the source of the goods. So if you're a church and you have a logo that incorporates your church name with maybe a little picture, like Santa Clara University, we have a little picture of the mission church and it says Santa Clara University under that. That's our trademark. We actually have that registered with the federal government. No one can use it without our permission. You don't have to register it with the federal government, but if you want some sort of added protection, if you want to use the legal system later on to protect your work, then it helps to register it. The duration of a trademark is about 5 years. So as long as you're using it, you're going to have protection. If you have a program and you've created a logo and you don't register it, it's an unregistered trademark, you have to make sure that you use it at least once every 5 years or so in order to keep your ownership over that. If you register it with the federal government, you just renew it every 10 years. You don't really even have to use it, as long as it's not completely abandoned. If you use it within the 10 years even once, you should be fine. Again, this is probably not something you really need to know, but if it ever comes up, you can refer to this slide. One issue that came up a lot, and there were a lot of questions surrounding in our last webinar, was use of photographs. When can you use photographs for your various publications, whether it's for church bulletins, your website, mailers, anything like that? It's important to know that pictures are copyrighted. You can't use a picture without the copyright owner's permission. A good rule of thumb is if you don't know who owns it, don't use it. It's easy to secure the rights of a copyright holder to a picture. It's really, you just ask them if you can use it and how you want to use it, and get in writing, even if it's just an email that says, yes, you can use our picture. If you hire a photographer and you want to use that photographer's work, make sure that you have a contract that tells that photographer that you will own the copyrights to all the pictures that he or she takes. I know that we've run into situations here at the university where a photographer has been hired very last minute. There was no time for a contract, which is understandable. Those situations occur. And then we pay the photographer, and then we say, now we want to use these photos, and the photographer will say, well, this is my copyrighted work. You have to pay me now extra to use the photos that I took of your event. So it's always great to have some sort of written agreement with a photographer who's working on your behalf before that person takes pictures of your event or whatever it is that you need. Even if a photographer is a volunteer, that person still owns the rights to the pictures that he or she takes. So it doesn't matter if you're paying your photographer, or if your photographer is a volunteer, that person will own the copyrights because that person took the pictures. So they own their work. So you want to make sure that they give you those copyrights so that you can use those pictures however you want in the future. If we've kind of covered this, but if you found a picture online and you don't know where it comes from and you want to know if it's copyrighted, because not all pictures are, especially if the copyright duration has passed, or if the picture was taken and the photographer says very publicly, anybody can use this, I know I own the copyrights, but anybody can have it. You can perform a reverse Google search. You go to images.google.com and you upload the photograph. It's not fail-safe, but it's usually a good starting off point. But always come back to the general rule of, if you don't know who owns the right to a picture, don't use it, because that person can then come back and potentially initiate some action against your organization for breach of their copyright.
He's back, and you'll have to just listen to it.
If you take pictures and there are people in your pictures and you want to be able to use those pictures, you can use a sample release. I have just a sample
It thinks it's there, but it's not.
It can be something really simple where you just make sure that the people in the picture know you want to use their picture for various reasons, or the person who took the picture, you want to be able to use their picture. So getting permission from people to be in a picture or to use their picture in some sort of advertising is really very simple. This is just a sample of what we use at the university, but it's not anything complicated. But if people have questions about that, we can definitely talk about it later. Use of copyrighted music. This was another issue that came up. It's important to note that the music industry is particularly litigious. We all have Napster to thank for that. Once file sharing of music became so easy and widespread, the music industry really started cracking down on people who were using their music without their permission. Music is copyrighted in the same way that photographs are. So before you use music in any sort of publication that's widely available, make sure that you get the rights from the copyright holder. And that can also be something as simple as getting permission via email. Usually with music, it's a big company that licenses all of these things and it's going to cost some money, but it's important to know that it's going to be, if you use music without permission, you're more likely to get angry notices from copyright holders than you are with pictures, just because of the nature of how easy it is to share music online. And then I think finally we have proprietary marks, which are really other companies' logos. Make sure that you don't use proprietary marks without the company's written permission, similar to photographs. And also, and this is one thing we're particularly careful about here at the university, is not to let third parties use our logos without our permission. You can signify to other people that you endorse a product or that you agree with what somebody else is saying if you let them use your logo. So policing how your logo is used by third parties is pretty important. And that can be a simple letter telling them to stop using your logo. So that's just a real brief and quick rundown. And now I think we can answer questions in a minute. If you have any questions and you don't have a time for us to address them today here, feel free to send me an email. This is my email address, colbert@scu.edu. While I can't give you legal advice, maybe there's something that we can talk through and just see if we can come up with a quick solution. So I'm going to stop sharing my screen and we'll go to questions. All right, I see there are 3.
Let me just make an announcement. So to submit questions at the bottom of your screen in Zoom, you should see something that says chat, and you can click on that and go ahead and submit the question. Let me just sort of start by tossing out a question that may come up frequently. You may often be, have you ever been in a meeting and you say, well, you know, the law says we shouldn't do this. And then people say, well, yeah, maybe in theory we can't really do that, but the risk is so small and so complicated going through these hoops. And how do you sort of like assess, you know, trade-offs that come up in those sorts of discussions?
That's a great question. And I work very closely with our risk manager here at the university, but we assess whether doing something that may get us into trouble outweighs the risk. So if you have, and this kind of goes along with your second question, if you use music in a mass that's publicly broadcast, what really is your exposure? It's probably fairly low. So you might say, we don't have time or we don't know who owns the copyrights to this music, so we're just going to use it and sit back and see what happens. And you have to weighing the risk of how much do you think it would cost to license this music for this mass? Maybe a couple $100. We don't have time to do it beforehand. Are we willing to just roll the dice and see if we get any sort of letter? It's probably fairly uncommon that you would, but if you do, you're probably looking at somebody demanding a couple $100 from you. And it might be worth it to you to just go ahead. So yeah, that is something. I'm not advocating for usurping somebody else's copyrights, but sometimes if you weigh the risks, you might just say, we're going to go for it anyway and see what happens.
Okay. So let's see, do we, why don't you just go in and, are there other?
Fair use. Yeah, so there's a question from David W. What can you tell us about fair use? Many of us publish newspapers and create news videos for use on YouTube. Fair use is something that I put in the slides for the last webinar, come out for this webinar, because fair use is a big doctrine and it's not clear, and some judges will weigh some way in fair use and some will weigh another. So what fair use says is that for certain purposes, like academic purposes or social commentary or social commentary, or if you're critiquing somebody's work, you can use that work. So if you want to write a review of a novel, you can't necessarily write a review without talking about the work, using the title, discussing the author, and maybe some key points and a couple of quotes to say this was a good novel, this was a bad novel, you should read it or you shouldn't. In the academic setting, you can quote from other people's copyrighted material in scholarly works because it's sort of critiquing. Social commentary, when you see like Saturday Night Live, they do funny skits about things that probably are copyrighted by other people, but what they're really doing is social commentary. They're not trying to use other people's work for their commercial benefit. I mean, ultimately it is because it's a television show, but they're trying to make a point about that copyrighted work. One important thing to know of fair use is that you can only use small portion of work in order to make your point. So if I want to talk about a new song that came out on the radio and I want to write a review of that new song, I cannot publish all of the lyrics to that song and then discuss all of them. I can take a snippet here and a snippet there to make my point, but the smaller amount of copyrighted work that you use, the better off you are to make a fair use argument. But again, there are many factors that go into fair use, and some judges view it one way, other judges view it another way. It's a doctrine, it's not really settled law. It's law, but it's not something where you're going to get the same results every time. It's really particular to how you're using something, why you're using it, and how much you're using of it. So fair use is complicated. Really, the main thing to remember is use it for non-commercial purposes, for academic purposes, social commentary, research, things like that. Use little of it as you possibly can, and then sort of keep your head down. Create videos. So if you create videos for use on YouTube and it's part of a published newspaper, as long as you use a small amount of the work and you use it as part of your newspaper and it's part of discussing the news, you should probably be okay, as long as you're keeping within those confines of the fair use doctrine. What do we need to know if we are going to video in ordination mass, which includes music? We turn that into a DVD and give that to the new priest and then post the video online. It's probably best if you expect that your DVD and your video are going to be widely publicized and used by many different people, to get the copyright holder's permission to the music. The more widely distributed your video is, the more likely it is that the copyright holder is going to find out about this and say, wait a minute, that's my copyrighted work. I didn't give you permission to use that, and now I want to charge you money. If it's one video that's, say, streamed live online, that's one thing. But if they can say, you have 5,000 units, and they were all sold, and now my copyrighted music is being seen 5,000 different times, they might want a lot more money from you, and they might have a pretty good argument. So in this case, it's probably a good idea to write to the copyright holders and just ask them if you can use their music in this mass and explain how it's going to be used and that you're going to make a video that you want to distribute to many people. And see if they give you the okay. They might say, sure, but we want you to pay $350, which would be pretty reasonable in this instance. But it's probably a good rule of thumb if you're going to publicize something very widely and in a permanent form like a DVD, that you get the copyright holder's permission first. And like I said, it can be as easy as sending them an email or writing them a letter and just asking. That's usually how we do it here.
See, there's another question from Paul.
This is not quite a copyright issue, but do we need permission to publish photos of people who attend an event that we sponsored? It's not quite a copyright issue. This is more of a privacy issue. Privacy laws vary state by state. But in general, a person has a right to their privacy and publicity. If you're at a public event, you probably don't have a reasonable expectation that it's sort of a private gathering. So if you have your picture taken, you're going to have a hard time arguing that there's some sort of violation of your right to privacy. Then there's the right to publicity, which also varies state by state. But in general, somebody can't use your image or likeness in order to profit. So if you have an event and you take pictures and you want to put those pictures online to show everybody how great your event was, it's probably going to be fine. If you have somebody who says, my picture was used on your website, I don't like that, then just take it down. That's probably going to be all they want, and that's probably the best thing you can do anyway. But if it's something where you're going to be using it in advertising, if it's going to be in a TV commercial, or you're going to be making brochures that are going to be distributed very widely throughout your state or throughout the country, it's probably best just to get a quick written release from the people who are easily identifiable in the picture. If you have, say 3 people that you can easily see and then a bunch of sort of fuzzy faces in the background, you don't need to worry about the fuzzy faces in the background. But those 3 people that are very easily identifiable, you just essentially ask them if you can do it and have it in writing somewhere where they say, yes, you can put my picture in this promotional material and use it in this way. We found that we very rarely get people who say no to that here at the university when we want to put their name or their picture or image or something in one of our brochures that goes out widely. We find that people usually like to have that. So we haven't found it to be difficult at all here at the university. And in the slides from this webinar and last webinar, I have just a quick, simple release that we use here at the university. We don't usually have to make any edits to it because it's pretty broad. It covers a lot of different things. So using something like that should be pretty helpful, keeping it to 1 page so that people can read it very quickly. And it doesn't have a lot of legalese or scary language in it, but it's very straight and to the point. I found that to be the most effective. Okay, so Matthew asked, does the copyright holder need to be paid by the church where the Mass is held and by the news organization covering it? Not necessarily. So if you have a missal so during a Mass, if you want to record that Mass and distribute it widely and you're worried about using somebody's music in it, if you have a missal that has a bunch of songs in it, they all have copyright notices on the bottom. But as the church, you bought the missal for the purpose of being able to have your congregation sing the songs. So I would say the church would probably not be held liable for any payments to use that music in the Mass. But the news organization that's covering it that wants to publish the Mass in some form, especially if it's to memorialize it on like a DVD or a video that gets sent out that's permanently fixed, that news organization would very likely need to get the copyrights if they include the entire Mass from start to finish. And it's not cropping, it's not just discussing the Mass and what happened in the Mass, it's really just a video of the Mass. So the person who's creating the videos or the DVDs would likely be the ones that would need to get the permission from the copyright holders. But if it's just streamed online, you're probably not going to need copyright holders' permission because that's very similar to people sitting in the congregation and singing the songs during the Mass. But again, if somebody happens to see your online streaming and says you shouldn't use our song, it's probably going to be a couple $100 that you would owe. It's not going to be a big deal. And yeah, the real issue that you'd run into is if you put it in a fixed form, like a DVD or a video, or you have a permanent link to it on your website, whoever created the permanent link or whoever really created the video is the one that would be responsible for obtaining the copyrights to the music that's used.
So Christian Gonzalez has a question. He says, let's say you have a colleague who says, hey, it's really no problem just taking a picture off a website and using it on a flyer or brochure. How do you demonstrate to that person it's a bad thing to do? Yeah, so we find that happens here at the university every now and then. You know, regardless of our best efforts to educate our various departments that is not what they want to do, it happens. I have found that there are, you'll get a letter, first of all, you'll get a scary letter. You'll get a really scary letter. So giving that coworker that scary letter and saying, this is the kind of trouble you're causing for our organization might be a good first step.
there have been a lot of companies popping up lately who represent huge groups of people who own copyrights. And what they do is they comb through the internet and see if somebody is improperly using their photographs. They aren't always legitimate, but the first thing to do if you get one of these letters, and what they usually look like now, and this is sort of a new thing in copyrights, is it'll say, we own the rights, or we represent somebody who owns the rights to this photograph. We found this photograph on your website. We have no indication that you requested the rights to use this photograph. Now we want you to take the photograph down and pay us $750, which is kind of outrageous, but it's usually in that range. Go to this website, give us your credit card number, pay this settlement, and everything will be fine. What I have found, and again, this is not legal advice, it's just my experience, is the first thing we do is we contact the department and say, is this picture put up on your website? And they will say yes, because you usually already checked and you know that to be the case. And then you say, where did you find this picture? Did you get the copyrights to it? Did you take the picture? Oftentimes they'll say, we just found it online. We thought it was a nice picture. We put it up. That's a really great educational opportunity for that department to say, here's a copy of the letter we received. You need to take it down immediately. Then what we've done is just not really responded to their demands for settlement. If they wanted to sue us, they could, but suing over $750 doesn't make a whole lot of sense. So we don't typically respond to those letters, but the first thing you do is you contact whoever it is who uploaded that picture, and you have them take it down immediately unless they can show you some sort of written verification that they obtained the copyrights to use the photo. What used to happen in copyright law was that somebody would say, you're using my photo, take it down. If you don't take it down, I'm going to demand money from you. Then you would take it down and that would be the end of it. But now these third-party companies have come in. They're very, very aggressive. They will send you many, many letters. And then you determine whether you want to pay the settlement that they're requiring or just sort of ignore it. But in any event, take the picture down and give your colleague that letter and say, this is what results from using an improper photograph that you don't have the copyrights to. Okay, from Penny, do you have any suggestions regarding contracts for freelance photographers we hire at newspapers who may also want to use the photos taken in an event for another publication? Yeah, what we use here at the university is a standard independent contractor contract. So if we want to hire a third party to take pictures for us, they're not our employee, they're an independent contractor, but we want to have some writing to memorialize that relationship. One, to ensure that they understand they're not our employees. Two, to make sure that they know exactly the work that we're hiring them to do. And three, to make sure that all parties understand who will own the copyrights to the finished product. So having some sort of quick contract that just says, you're going to come take pictures for us, you're going to give us the rights to those pictures, but in this instance you could say, we will own the copyrights, but we will license them back to you so that you can use them in these other ways for either this period of time or forever. That's not an uncommon thing, especially if you want other publications to be able to use those pictures because it's good publicity for you, but you don't want to have to call every single newspaper. If you have a photographer that wants to do it for you, great. Just say, we give you a license to use these pictures for this reason and for this long. It's really fairly simple. And if you want to send me an email later and you have a sort of a specific way or question about that, I maybe can send you some sort of standard contract language that I encounter. I deal with all the contracts on behalf of the university, so I see these frequently. But it's a really simple transaction. Photographer takes pictures. We, organization, own the copyrights, but we essentially give you permission to use these pictures in other ways. So that's a simple relationship that you can establish with a quick contract that you get the pictures and they can use them in a way that you approve. How can we protect our materials from being repurposed? Is this something we should? I'm not quite sure, Maldonado or Patricia, what you mean by protecting materials from being repurposed.
Let me just jump in. Let's say she's editing a newspaper and she wants to make sure that her photos don't show up somewhere. How can she best protect herself from having that happen?
Well, it's tricky and it's tough. You have to essentially do a lot of online searching to see if somebody else has uploaded your photos. And if they have, then you send them a letter that says, you can't use my photos. I own the copyrights. Take them down immediately. And if they don't, then you can send another letter that says, do it now, or I'm going to essentially seek monetary damages against you. It's not easy to police other people's use of your work. It could be a full-time job. That's why a lot of these people use these third-party companies that are very aggressive, because the third-party companies have a lot of time to do this, whereas the average person doesn't. But one good idea is on your graphics and photos and writings to put a copyright notice. Again, putting a copyright notice doesn't mean that you've registered your work with the federal government, because you don't have to, but it's letting everybody know that you own the rights to that work. So if you have a photograph and say you're a school, then on that photograph, just put the C with the circle, the date, the year essentially. Say it was a photograph taken in 2016. So it'd be a C circle, 2016, and the name of your school. And then anybody who wants to use that photograph without your permission is on notice that you own the rights to that, and they should come to you to get them. And then if you find somehow that a third party is using your photograph or your graphics or your writings, you contact them and tell them to stop. And depending on how important it is to you to make sure that they stop, sort of your last resort would be to have your in-house counsel, if you're a big university, or your outside counsel sue them. It's not easy and it's not cheap, but if it's something where you really worry about the reputation of your organization or about the privacy or publicity rights of your people, then that's sort of filing suit usually gets people to listen and to do what you need to do. But that would be your last resort. The first thing to do is put a copyright notice on everything that you have. And I think it was my third slide where I showed the copyright notice that the Catholic Academy put on the email that they sent out for this meeting. It's that simple. You don't even need to write the word copyright. Just the C with the circle is good enough, the date and your organization's name. And trying to make that a general practice among all of your employees is a really good way to ensure that all of your work has the copyright notice, and then anything that comes out of your organization is uniformly copyrighted and everybody knows not to use that without your express written permission.
Let me ask, if I can, a follow-up question on that. Let's say I give a reporter a photograph which belongs to our organization, and then that's published somewhere, and then someone finds the photograph and starts using it in a way that I don't like. How much, to what extent have I lost ownership control over that photograph by giving it to a media organization for publication?
You have not lost any control. You still own the rights to that photograph. What you have done is allowed that media outlet, that single media outlet, to use it in one particular way. So it's a good idea, one, to make sure that you have your copyright affixed to that photograph, and you tell that media outlet, hopefully you have some sort of agreement, even if it's just an email, where you say, news channel, you are allowed to use this photograph regarding this story, and make sure that you keep my copyright notice on there. And then anybody else that would use it without your permission is still violating your copyright. So just by allowing one person or party to use your photograph doesn't mean that you lose any rights to it. All you've done is said that it can be used by this one person or party for this one or multiple purposes. But you don't have, that doesn't mean you lost anything with regard to anybody else. Okay, so here we've started putting a general statement of photo permission on registration forms. It says something like, by attending this event, I give permission for my picture to be used as opposed to an individual release. We often sort of rely on the expectation of privacy tests. Your thoughts? That's probably fine, especially if you have a big event and you know there are going to be a lot of people there. They're going to see a photographer roaming around taking pictures. If they really don't want their picture taken, they will say, don't take my picture. If they don't, not only do you have that person having their picture being taken without objecting, and you have this release, this general release, you're probably going to be fine. If you want to, even if you want to use those pictures, as long as you let people know beforehand in this general release that you're talking about, this statement, that you might use it for promotional purposes, you're also probably okay. But if you're going to take a picture and you think it's the greatest picture and it's of, say, 3 people at your school festival and you want to use that for a huge marketing campaign, it's probably a good idea to get their permission again, just to make sure that they're comfortable with their photo being used in that way. You're probably not going to run into any significant issues if you don't, but it's good relationship building with your congregation. And it's just sort of the right thing to do to make sure, if you're going to use this photo really widely, that the people in it know that that's what you want to do. One thing to keep in mind, and that we are particularly sensitive about here at the university, is photographs of minors, anyone under the age of 18. We have really a general practice that we don't use photos of minors or take pictures of minors without their parent or guardian's permission. We don't want somebody to come back and really have any issue with our use of pictures of minors. Again, it's just a sensitive subject. We always want to make sure that we have parents' written permission before we use photographs of minors. So if you have that same wonderful picture from your school fair, but it's of 3 kids, I would make sure that I get a signed written release from the parents before you use that picture publicly, widely. If it's something where you just put it in a bulletin that only goes out to the student families or just your congregation, you're probably going to be okay. But if it's a brochure, you want to put it on your website, or you want it to be distributed past just your congregation, I would make sure to get some sort of written release from a parent or a guardian before using that picture. My email address is on the last slide, but it's B, my first initial, Colbert, which is my last name, COLBERT @scu.edu. So again, feel free to email me if you have any other specific questions that maybe we can talk through. Okay, and then Father Sukup asks, if we are preparing for a diocesan educational event, can we rely on fair use to duplicate, say, an article we want people to read? To duplicate an article you want people to read, it depends on how you want to use it. If it's a diocesan educational event, that would seem almost like what we do here in our library, where we tell students that they'll have to read an article and we print it out. But usually, we do have permission from the copyright holder to do that. In this instance, I don't even think fair use would come into play, because you're going to be duplicating the entire article. And if you duplicate a whole work, fair use is out. Fair use only counts if you duplicate small portions of it. Here, it would be an educational event, so fair use would have worked there, and if you only gave them part of an article, then you'd be okay. But duplicating a whole article, fair use is not going to apply, but the chances of you running into any big copyright issues are pretty slim. So it's still probably going to be okay, because I just don't see how somebody is going to come after you and say you shouldn't be doing this, especially if you want to use an article as part of a teaching thing and it's only going to be distributed to a small number of people. If it's a whole chapter of a book and you want to copy it and give it to everybody and have them read it, technically, yeah, that would be a violation of the copyright holder's rights. You should have permission from that person, the copyright holder, or you should tell everybody to go buy the book. But if it's just an article and you want people to read it before an educational experience for a smaller event, you're probably going to be okay. Here's a question about minors. In regards to minors, if the kids are in the Christmas pageant play during Mass or presenting the Stations of the Cross, is there a reasonable expectation the pictures will be taken? Yeah, probably. There's probably a reasonable expectation. Also, their parents are probably also going to be there. So having a photographer taking pictures of kids in a pageant while their parents are watching, I don't think you're not going to run into a privacy issue. But then if you get the best picture of somebody dressed up like an angel and you really want to use that in a new commercial to promote your church, I would get permission from the parents before you do that. Just taking the pictures, you're probably going to be fine, again, because their parents will likely be there. But when you want to use those pictures to promote your organization widely, it's a really good practice just to get the parents okay before you do it.
Let me ask a question about protecting trademarks. I understand that if you don't move to protect your trademark, you risk losing it.
Mm-hmm.
And my question is basically, how aggressive do you need to act in doing that? But let's say, like it happened to us one time that someone came out with Opus Dei jeans. Some tiny guy, almost basically working out of a basement, was selling these Opus Dei jeans that he had created, and somehow we heard about it. And so, do we risk losing the Opus Dei trade service mark if we don't go after this guy in the basement who's selling his Opus Dei jeans?
You probably don't lose your trademark from that one instance, but if his jeans become somehow very popular and then he tries to register Opus Dei as his trademark, you could run into a problem. But if it's just some guy in a basement, you should be fine. I would still send him a letter and tell him to stop, because again, you don't know, maybe he's some budding designer and he's going to come up with something amazing, and these are going to be the next big thing in jeans. Then you could run into an issue. I would say anytime you find somebody using your trademark without your permission, and they're either one, endorsing a product and making it look like they are you, or they're using your trademark as their own, I would write them a letter and tell them to stop. Because one issue that you could run into, it's pretty unlikely especially in a smaller organization like just a church or a school, but a bigger organization like Opus Dei is you can lose your trademark if other people use it and you don't do anything about it. Or if your trademark becomes generalized. That's a problem that Google faces all the time. If you watch a movie and you see people say, they don't say Google it like they do in real life, they say do an internet search. It's because Google probably tells everybody you can't use our trademark, because if it becomes so widely known, it becomes a generalized term and they don't own it anymore. That's why the Band-Aid commercials, they change their song from I'm stuck on Band-Aid to I'm stuck on Band-Aid brand, because Band-Aid has become such a common term for a bandage that they risk losing their trademark altogether. So I would say anytime you find somebody improperly using your trademark or your logo or your seal or anything like that, write them a letter and tell them to stop, because if nothing else, you're showing that you're defending your trademark, and you can, you've sort of got a leg up at that point.
Okay, I'd also like to say that we're unmuting the phone lines in case there's somebody out there speaking, listening by phone. If somebody wants to jump in and ask a question, you're welcome to do that. And all right, very good. I think we may be getting close to the end of our time. Penny, I'm sorry, Bridget, any sort of like last minute thoughts or anything else in particular you'd sort of like to stress or make sure that people remember?
I think that when it comes to intellectual property and using somebody else's intellectual property, really the general rule is if you don't know where it came from, don't use it. But also, if you do know where it came from and you know you don't have the rights to it, it's really easy to just fire off an email or send a letter and ask for it. It seems like an insurmountable task to try to get somebody's permission to use something, but we found oftentimes it's really pretty easy. In fact, there was a YouTube video that was created by a huge company in another country, and our business school wanted to put it on their website. And I said, just send them an email. Their email was on the YouTube video, and just ask them. And sure enough, they said, sure, you can use it. Great, put it on your website. And the whole thing took maybe an hour. So it's not difficult to just reach out and ask somebody if you can use their copyrighted or trademarked work. But if you don't know where it came from and you know you don't have permission, don't use it. Those are pretty much the two, I think, key things when it comes to using someone else's intellectual property. And then David did have a question about YouTube. So YouTube videos are owned by the copyright holder. So whoever created the video, or yeah, whoever created the video still owns the copyrights to the video. But when you read through YouTube's terms and conditions, which are long and complicated, and I've had to read them several times, they say that the copyright holder, by posting the video on YouTube, gives YouTube the rights to use the video pretty much in any way that it wants. But you, as a third-party viewer, you're not given any rights to a video on YouTube. So if I create a great home video and I think it's wonderful and I post it on YouTube, I still own the copyrights to it, but YouTube can do whatever they want with it. So when my wonderful video goes viral and it's posted on news outlets all over the place and on other websites, that's because YouTube said, hey, other people, we have the license to use this video. You can make it available on your websites as well, but I still own the copyrights to it. So don't just use YouTube videos and post them on your website unless you created the videos or you are the copyright holder. Just write to the copyright holder and ask them, because they still own the rights even though they posted the video on YouTube.
Very good. Well, I think we're just about out of time right now, but Bridget, thank you so much for joining us. Would you repeat your contact information one more time in case people have other questions they might want to send you directly?
Sure. That's my email, bcolbert@scu.edu.
Okay, excellent. That's very generous of you. And the presentation that you had is also up on the Catholic Academy website, the detailed notes from the first presentation. So everybody, thank you. Thank you for joining us. If you want to, we're also going to be posting this, and the presentation will be on our website, catholicacademy.org. And thank you for joining another webinar